afternoon, Chairperson and Dr. Jeewanthi and other distinguished guests and students. Actually, I will quickly go to my presentation. The topic of my research paper is the new eye for sentencing juvenile offenders. By looking at the topic, you can understand it gives some sort of new view for sentencing juvenile offenders. When we move into the scope of this study, actually first of all I should say what I presented here is a small part of a big research. Actually the wide research is this is not a completed research, but this part is a small part of that big research. It is coming under the juvenile justice, and in this paper I will discuss only about the juvenile delinquent or the juvenile offenders, and more preciously I would discuss about the sentencing or the court orders part. And within the one hand the juvenile delinquent, and the other hand I would discuss the applicability of restorative justice principle relating to juvenile delinquent, because the large study is basically doing to understand to what extent the restorative justice principles are practiced in the Sri Lankan context and move forward to implement these procedures in the Sri Lankan system. As I told you, the wide area of this research is compounded with both normative and empirical study, but this paper will limit it to the normative study, which gather the theoretical base of applicability of the restorative justice principle to the juvenile justice system of Sri Lanka. The wider area will be compounded with the empirical data. When you're looking into the juvenile justice system in international level, as we all know, the CRC, the Convention on the Right of the Child, is the main document which deals about the rights of the child, and there are four main principles mentioned in the CRC: the non-discrimination, best interest of child, right to be heard, and right to be survived. Actually, these four principles have not clearly mentioned in the juvenile justice. There are separate provisions relating to juvenile offenders in the CRC, but we can say that these main four principles are applicable for even to juvenile offenders. And apart from the CRC, there are the guidelines such as Beijing, Riyadh, and so many other documents which are relevant to juvenile justice, but I am not discussing this in here. The Sri Lankan juvenile justice structure, as we know, the penal code, as Chairperson said, it was enacted somewhere in 1883, and the minimum age for criminal liability is set for age 8, and SIPO, Children and Young Person Ordinance, is considered as the main document regarding juvenile justice, and this legislation addresses the rights and interests of a child or young person who is facing a charge for an alleged offence or who is a victim of an offence. And apart from the SIPO, the Probation Ordinance, Community Service Act are dealing with this matter. And recently Sri Lanka opened juvenile court in the Jaffna. Till that we had only one juvenile court in Colombo. Okay, one hand I discussed something about the juvenile justice in international level and Sri Lankan level, and as I told you, I'm looking at this with the restorative justice angle. What is meant by the restorative justice? Restorative justice, actually this is normally the restorative justice is compared with the retributive approach. Retributive approach is normally deal with retributive justice consider punishment as the best form of reaction to crime, while the restorative justice focuses the reformation of that particular offender is the main best response for a crime. Restorative justice, the offender is the main focus, and this model it seeks to change the future behavior of the offender, and it attempts to achieve justice by getting the active participation of victims, offenders, and community members. Actually, when we're looking at the Sri Lankan context, we know that victims have problems in the Sri Lankan system, and we don't have even the victim witness protection laws we don't have. But restorative justice, it's targeted to get together, have main in discussion with the victim, offender and the community as a whole. And there are set processes in the restorative justice victim offender reconciliation program. In that program, victim and offenders are given the opportunity to meet together with the assistance of a trained mediator to begin to resolve the conflict and to construct their own approach to achieving justice. Family group conferencing or the conference is one other made of process. This is not only the victim and offenders but also the family members or supporters of victims and family members can participate in this process. Actually, I believe for juvenile justice, the family group conferencing will be a good solution. Victim offender panel, this is compounded by a group of victims and group of offenders who are usually linked by a common kind of crime, and then again circles which are giving more space for community, like community meetings. Okay, what are the advantages of restorative justice compared with the retributive approach? Restorative justice permits greater participation and satisfaction for victims than the existing ecosystem. This permits greater participation for offenders than the existing legal system. And restorative justice considers the reparation of harm as the appropriate response to crime, as I told you, while in the retributive justice it considers the punishment as the main form of reaction to crime. And restorative justice allows better reintegration for parties. Because ultimately, what is the objective of a criminal justice system? The objective of criminal justice system is to reintegrate these offenders. Someday they will come back to the society again. They may have got punishment in for 5 years or 10 years or whatever the year, but once they finish their punishment, they will come back to the society. So there will be a procedure to reform this. And the restorative justice allows participation even for community. Okay, when looking at the Sri Lankan context, by and large, Sri Lankan penal system is based on the retributive justice model. Actually, from the way our penal code has text and the way the language used gives a clear indication of the legislature's intention to give the retributive disposition to the penal code. For example, I can say the section 52 of the penal code sets the punishment, and in this, there are 6 modes of punishment: death sentence, aggressive imprisonment, simple imprisonment, and whipping, fine, and such. In this model, by looking how that section also says, we give the retributive approach. And again, though we have some probation ordinance, community service correction act, all we have, but the usage is not popular as that punishment model. Actually, this retributive approach has influenced to a certain extent to the juvenile justice administration also, because when you're looking into the statistics, actually these statistics I have taken from the prison website, it shows the number of convicted prisoners in the prison. 2007 to 2010 it's a less number, but in 2011 it has mentioned as 102, and 1622 also this is the amount. Okay, we identified by and large Sri Lankan system, Sri Lankan law penal system has taken that retributive approach, and within the juvenile justice scope, I found out few orders or the sentence we can say, which gives some sort of alternative forms of sentencing. For example, fixed person ordinance, restricted imprisonment for child who below age 14, delivering to parent or guardian with or without bond, discharging conditionally, probation ordinance, ask for report of the commission such as. Then Mediation Board Act provides provisions for certain penal code offences referred to the Mediation Board in the first instance. But there are procedures mentioned regarding the juvenile justice. However, there are some reports have developed by, for example, some reviewers report and some individuals, some reports have find out, though we have some alternative methods which are little bit similar, have some features of the restorative justice, they are not functioning as intended, because some problems they have identified. Reform homes are used as alternative for imprisonment, and remand homes, food schools are overcrowded and they are poorly equipped. Limitation to usage of Community-Based Correction Act, because in our Community-Based Correction Act there is a limitation, so it is not applicable for serious offences as such. Then actually the probation orders procedure in the Sri Lankan context, it is we can say it has meant to be a good piece of legislation, but there are practical defects, especially because the probation ordinance have to be activated with the human beings, but lack of trained probation officers, lack of fit persons has led to that probation ordinance in not coming to the accepted objectives, and the mediation board provision also not performed as intended. So then what is the conclusion? As I told you, this is a one small part of a big research, and I have taken the Sri Lankan system and the principles of the restorative justice and do some comparison and find out how this we can add them. Sri Lankan penal system is more retributive in nature, but in juvenile justice administration some unique features can be seen which comes under restorative justice model. However, the laws are not functioned as it is and have some practical limits. Therefore, expected restoration cannot be seen in the Sri Lankan context. I can see a need and space for called restorative justice processes into Sri Lankan juvenile justice.